Good afternoon and welcome to our webinar, the third in a series exploring the life cycle of a contract. In the previous webinars, my colleagues explored the birth and infancy of a contract, and then we looked at the teenage problem years, and today we're considering middle age and divorce. Before we start the webinar, I should make you aware that to keep background noise to a minimum, we've placed each of you on mute. However, if you have any questions, please do use the chat function throughout the presentation, and we shall pick these up at the end. We've tried to make this webinar as interactive as possible, so please respond to our surveys and use the voting buttons when prompted. I'm Alastair Brown, a solicitor in our commercial disputes team at Stockford and Wedderburn, and I'm joined today by Claire Stockford, a partner in the firm's international disputes team in our London office. As dispute lawyers, we're involved in dealing with contractual disputes in a variety of different sectors, and by working with other lawyers who specialise in a wide variety of legal sectors, we're able to develop and tailor our own advice based on the particular legal problem being faced. So in today's webinar, we are looking at middle age and divorce in the life of a contract. At this time, cracks can start to appear in the building blocks of a contract, and today we'll help you to identify whether these cracks are serious enough to consider walking away from the contract entirely. Importantly, once we've helped you to know when to remove yourself from a contract, we'll provide some practical advice on how to do so. Just to say, in our final session in this series will be on death and estate planning, or in other words, how to plan for the demise of a contract. We've put the date of this webinar on the screen just now, and we hope you can join us. So, today we're going to focus on three areas where disputes can arise. These three areas are repudiation, fundamental breach and material breach, renunciation and specific performance, and finally, limitation of liability. And we'll illustrate some of the difficulties that can arise in these areas with three recent cases. And I'll now hand over to Claire.
Our first focus area is repudiation of contracts, fundamental breach and material breach of contract. Before we go on to look at case law examples of what constitutes a repudiatory breach, fundamental breach or material breach, it is worth going back to basics and considering what each of these three terms mean in contract law. The first type of breach that we'll look at is repudiatory breach. Repudiation is a breach of contract that gives the aggrieved party the right to choose either to end the contract or to affirm it. In either case, the aggrieved party may also claim damages for any loss sustained as a result of the breach. When we consider what will constitute a repudiatory breach, it helps to think of it in terms of which part of the contract has been breached. The terms of contract can largely be divided into three categories: 1, conditions, 2, innominate terms, or 3, warranties. A condition is a term so vital that it goes to the root of the contract and is therefore a major term of the contract. Where a breach of condition occurs, then this will give rise to the claimant's right to terminate. That is to say, the claimant can treat the contract as discharged and claim damages for any loss sustained. An innominate term is the middle ground, and the effect of a breach of an innominate term will depend on whether the breach substantially deprives the innocent party of the whole benefit of the contract. If it does that, then the effect is the same as for the breach of condition. Finally, a warranty is the most minor of these three types of terms and is not so fundamental to the contract. As you would expect, the effect of breaching a warranty is not as serious as breaching an innominate term or a condition. So once you've identified the type of term that has been breached, you can then decide whether the breach is repudiatory. If the term is a condition, or if you breach an innominate term which has the effect of substantially depriving the innocent party of the whole benefit of the contract, then this will usually be a repudiatory breach. Parties to a contract should also be aware that terminating or purporting to terminate a contract without sufficient basis to do so can itself be a repudiatory breach. This makes it particularly important to properly assess the extent and scope of any breach. Now we've all had a refresher as to what repudiatory breach actually is, we can look at fundamental breach and material breach. Fundamental breach is usually considered as synonymous with repudiatory breach, and the two terms can be used interchangeably. With that in mind, the principles that we've just discussed in relation to repudiatory breach are equally applicable to fundamental breach, so we needn't expand on this any further. A material breach is a degree lower on the scale of seriousness, and the remedy for material breach turns on all of the surrounding circumstances. Remedies usually include damages or specific performance, but in some rare cases, contracts will allow for termination following a material breach. Often, it will be necessary to consider the reasons why the breach occurred, the provision, if any, of the contract, its impact on the innocent party, and the nature of the contract and the obligations involved. In considering all of these factors, parties may be able to come to an agreement as to the best next steps that they can take. So to recap, we have repudiatory breach or fundamental breach, which is a serious breach, usually of a condition or an innominate term that goes to the heart of the contract. The remedy for this type of breach is the aggrieved party's decision of whether they wish to affirm the contract or terminate. Regardless of which remedy they elect to go for, the aggrieved party is entitled to damages. You also have material breach, which is less serious than repudiatory breach. It occurs following breaches of more minor terms or warranties within contracts, and remedies include damages, specific performance, and in rare cases, termination. Now we have defined the terms, we can take a look at a court decision on what constitutes a repudiatory breach. So this takes us to our first case study, which is Eminence Property Developments against Heaney. This case looks at whether mistakes made in termination notices will repudiate a contract, even where the parties did not intend repudiation to be the outcome. So the facts of this case are as follows. Eminence Property was the owner and seller of 13 flats. Heaney was the purported buyer of these flats from Eminence. The date for the completion of sale appeared to have come and gone without the contract being completed. As a result, Eminence instructed its solicitors to serve notices to complete. These notices were served on Heaney's solicitors in terms of Clause 6.8 of the Standard Conditions of Sale between the two parties. In the covering letter that accompanied the notices to complete, it was stated that Eminence had calculated the final date for completion to be the 15th of December 2008. On the 17th of December, Eminence's solicitors sent notices to Heaney which purported to rescind the contract. However, the original calculation of the final completion date had been incorrect. Instead of the 15th of December, the final completion date should actually have been the 19th of December. Therefore, the notices which Eminence had sent to rescind the contract were premature by 2 days. Heaney felt this was a repudiatory breach of the contract between them and Eminence. As you will remember, we discussed earlier the importance of having a basis for termination of the contract, otherwise you can end up being in repudiatory breach of the contract yourself without intending to be. At first instance, the recorder decided that Heaney was correct. Whilst the inclusion of the incorrect date had been an unintentional error, that did not provide an adequate basis to excuse the fact that Eminence had attempted to terminate the contract without a proper basis. Eminence decided to appeal the decision, and so the issues were taken before the Court of Appeal. So the question is, was Eminence in repudiatory breach of their contract by attempting to terminate the contract without a proper basis? We're now going to go to our first poll, the interactive part, and we'd ask you to use your voting buttons to respond to the question, which is on your screen now. So the question is, was Eminence in repudiatory breach of the contract with Heaney because they attempted to terminate the contract without a basis to do so? Click A if you think yes, Eminence was in repudiatory breach, and B if you think it was not.
You can actually see it's pretty evenly split between the two, so a dead heat.
A dead heat. The answer is actually B. Eminence was not in repudiatory breach of the contract by seeking to terminate it without the correct grounds. Let's look at what the court said. The legal test for repudiatory conduct was simply stated. It was whether, looking at all the circumstances objectively, In other words, from the perspective of a reasonable person in the innocent party's position, the contract breaker had clearly shown an intention to abandon and altogether refuse to perform the contract. Whether or not there had been a repudiatory breach was highly fact-sensitive. All the circumstances had to be taken into account in order to form an objective assessment of the contract breaker's intention. Motive might be irrelevant if relied on solely to show the contract breaker's subjective intention. However, it might be relevant if it was something of which the innocent party was, or a reasonable person in its position would have been aware, and threw light on the way the alleged repudiatory act would be viewed by such a person. In this case, the rescission notices did not constitute a repudiatory breach of the contract. Among other things, Eminence was, as required by the standard conditions of sale, ready, able and willing to complete. As a reasonable person in Heaney's position would have realised, there had been a simple error of calculation by Eminence's solicitors, which once pointed out would have been conceded immediately, as was the case here. The consequence of pointing it out was that the rescission notices would have been treated as ineffective, and Eminence would have waited until expiry of the notices to complete before deciding whether or not to treat the contract as at an end. It was impossible to find an intention by Eminence to abandon and altogether refuse to perform the contracts, which in view of the state of the market had become highly advantageous to Eminence and onerous to Heaney. On the contrary, the obvious inference was that Heaney and its solicitors were only too aware that Eminence wanted to enforce the contracts, either by completing them or by rescinding them and exercising the remedies available in accordance with the contractual terms. Although this case is now 7 years old, it has been improved of more recently in England and Wales, for example in the 2016 case of regular ship services against London services. It favours a more common sense and commercial approach to the idea of repudiation in contracts. So what practical lessons can we take from this case? Firstly, always be mindful of any notices you serve. The devil is, as they say, in the detail. The saving grace for Eminence in this case was the wording of Clause 6 of the Standard Conditions of Sale, which showed a clear and unambiguous intention not to want to terminate the contract in the first instance. That said, the courts may not always look so favourably on parties that serve notices that are incorrect. By attempting to enforce performance, you could actually inadvertently repudiate your contract if you aren't careful. Secondly, consider whether or not you want to include a passage in your notices which states that errors in the notices will not lead to those notices being ineffective, or that you will not abide by the contract terms. A clause like this is a double-edged sword. It could help you get out of a sticky situation should you accidentally potentially repudiate your own contract through error, but equally it may have the opposite effect of making your notices ineffective even in circumstances where you want them to take effect. We would advise that you take legal advice on this point before including anything that could have an unintended effect in your notices.
Let's now move on to our second focus area. So we've already discussed the idea of repudiation, but what about a situation where one party makes it clear that it has no intention of carrying out its contractual obligations or duties? In contract law terms, this is known as a renunciation. A renunciation under a contract can be intimated to the other party either through words or conduct. This can be in a number of ways. For example, a party may expressly declare that they do not intend to perform under the contract. Alternatively, a party may fail to prepare adequately in the lead up to the time of performance. It's also important to remember that renunciation can occur before as well as at the time that performance becomes due under the contract. When working out whether or not there's been a renunciation, there are two main ways in which this can be communicated. These are either an express statement from the other party that they have no intention of performing their obligations, or short of an absolute refusal to perform, the test is whether the actions of the defaulting party would lead a reasonable person to conclude that the other party no longer intends to be bound by the contract, and whether the non-performance of that obligation would entitle the innocent party to treat the contract as terminated. So imagine a situation where you have a contract in place with another company and the time for performance under that contract is approaching. A representative of that company comes to you and says that the company will not perform under the contract. What can you do? Well, one course of action would be to consider obtaining a court order for specific performance. Specific performance is an equitable remedy available for breach of contract. It's less well known than the remedy of damages and will only be appropriate in certain circumstances. Essentially, the court order will compel a party to perform its contractual obligations in place of or in addition to damages. However, unlike damages which are available as of right, specific performance is granted at the court's discretion. There are a few considerations that the court must bear in mind before it decides to grant an order for specific performance. These include that it's not available where damages alone would be an adequate remedy. It will not be granted where the court requires performance to be supervised by a court over a period of time. The courts will also have to consider whether such an order would cause the defendant to suffer hardship. Specific performance will not be ordered if the contract is for a nominal consideration. And finally, the court will consider the conduct of the claimant, as anyone who is guilty of improper conduct will be barred from obtaining the equitable remedy of specific performance. So let's have a look at how the courts apply this in practice, and to do so we'll look at the High Court case Airport Industrial GP Limited versus Heathrow Airport Limited and AP16 Limited. The facts of the case briefly are as follows. AP16 Limited was the second defendant in this case and the leaseholder of a site at Heathrow Airport. AP16 was obliged to build a car park that provided 280 spaces for, amongst others, Heathrow Airport Limited, HAL, who was the first defendant in this case. The completion date for the work was the 22nd of October 2016. 1 year prior to the completion date, AP16 had not undertaken preparatory work in relation to the car park. It was HAL's opinion that AP16 no longer had enough time to complete the car park. Whilst there was still almost a year left to run before the completion date, the complete absence of preparation of the site made the task, at least in HAL's mind, impossible to perform. Therefore, HAL sought a court order for specific performance of the obligation to build a car park, despite the fact that the car park was not technically due to be built at that point. It transpired that AP16 wanted to build a multi-storey car park with more than the allotted 280 spaces, which would in turn allow AP16 to earn money from the charges for those additional spaces. However, HAL wanted a surface car park to be built, which did not require additional car parking spaces to be included. AP16 denied that any obligation to build the car park had yet arisen, though it did accept that if the car park was not built by the completion date, then it would be in breach of the contract with HAL. So the issues that the court had to determine was twofold. One, could specific performance of the contract be ordered, given that the completion date had not yet arrived? And secondly, the court had to decide whether, in all the circumstances, specific performance was an appropriate remedy. So this brings us to our second poll. And before we find out what the High Court had to say, let's see what you think. So the question is, could the court order specific performance even where the contractual completion date had not yet passed? If you think yes, they could, then please select A. If you think nope, they couldn't order specific performance in those circumstances, please select B. And a majority of you have gone with yes, the court could order specific performance. And I'm pleased to say the majority of you were in agreement with the High Court. The High Court found that specific performance could be granted against AP16, albeit that the court in fact allowed a 2-year extension to the completion date. The court also allowed AP16 to build the multi-storey car park project rather than the surface car park. The order was made subject to the condition that AP16 deposited funds to cover any losses suffered by HAL as a result of AP16 proceeding with the multi-storey car park option. In addition, AP16 was required to achieve certain planning and construction milestones over the extended period of time, failing which it would have to build the surface car park instead. In its reasoning, the court recognised that it could not compel AP16 to complete the car parking spaces before the completion date. However, the court decided that it was able to order that AP16's contractual obligations should be performed, and in addition to this, the court felt that it was able to give directions as to the steps to be taken to bring about this specific performance, such as the planning permission milestones that had to be reached. Clearly, the court was alive to the commercial realities of the situation. It recognised that without the additional revenue which would be gained by AP16 through a multi-storey car park, then it was likely that AP16 would face serious financial difficulty. As such, in considering the impact on both HAL and AP16, the judge decided that it would be disproportionate to punish AP16 by preventing it from being able to make a profitable use of the site. This judgment is quite surprising though. Specific performance is often not considered to be appropriate in construction contracts because performance occurs generally over a long period of time. As such, courts are usually unwilling to supervise the performance. Perhaps of note in this case was the fact that the court ordered steps to be taken to complete the work, and individually these steps could be subject to supervision by the court. So following this judgment, what are the practical points that can be taken away? Well, we can see that the courts are willing to take into account the commercial realities of a situation. AP16 was able to build a multi-storey car park given the financial consequences of the alternative. But this can work both ways, and where specific performance would assist a claimant rather than the defendant, the courts will also take this into consideration. Practically, the case highlights the use of specific performance as a remedy, so where a contract breaks down, it's always worth asking the question, is specific performance available? Before we turn to our final focus area for today's webinar, we thought it might be helpful to have a quick recap on damages as a contractual remedy. Damages are much more common than specific performance, so it's useful to refresh our memories on the basic principles. Generally speaking, an award of damages for breach of contract is to compensate the injured party for loss rather than to punish the wrongdoer. The general rule is that damages should, so far as possible, place the claimant in the same position as if the contract had been performed. An exception to this general rule is exemplary or punitive damages, which are damages awarded in excess of the actual loss suffered, and they are intended to punish the defendant rather than compensate, although they're only available in very limited circumstances, and the English approach to punitive damages is in stark contrast to the position in the US, where these are the norm. Another category of damages is equitable or restitutionary damages, which require the defendant to pay the claimant's profits enjoyed as a result of a breach, and relief is granted to prevent the defendant from being unjustly enriched. That said, for the court to order restitutionary damages, it has to be shown that the case is exceptional and that compensatory damages would not be a sufficient remedy. A crucial point then is in calculating the loss resulting from the breach. And briefly, the most common measures of damages are expectation loss, which looks at the innocent party's loss of bargain, and secondly, reliance loss, which refers to the expenses incurred by an innocent party in reliance of the contract being performed. Just remains to be said that calculating the loss in certain types of dispute can be complicated, so you do need to factor in sufficient time to enable you to assess your loss before bringing a claim, although that's not always possible when there are limitation issues. And it's also worth remembering when framing any claim that liability may go beyond contractual liability, and there may be concurrent liability in tort, which will obviously broaden the scope of any damages claim. So, now we've had a quick look at damages, let's move on to our final topic, which is limitation of liability. So, liability for breach of contract can be limited in two ways. It can be limited by express contractual term or by disclaimer. In order to limit liability in either of these ways, the limitation must be properly incorporated into the contract, if by express contractual term, or if by disclaimer, it must be brought to the other party's notice in clearly expressed terms. It has to cover the circumstances of the breach in question, and it can't be undermined by any misrepresentation. In addition, always bear in mind that the normal rules of construction of contracts apply, in particular the contra profferentum rule, which broadly states that where there is doubt about the meaning of a contract, the words will be construed firstly against the person which seeks to rely on a particular interpretation, and secondly against the party who drafted the clause in question. Any clause excluding liability must be clearly and unambiguously expressed, so careful drafting is needed to ensure there's total clarity. So how will the courts treat attempts to limit liability?
We have a case study now on the limitation of liability, and it's a Supreme Court case called Impact Funding Solutions against Barrington Support Services, with AIG Europe as a third party to the proceedings. The background is that Impact Funding provided loans to people who wished to start a court action. They had an agreement with Barrington, a law firm, which meant that Barrington could access their database, take on the claims of various claimants, and draw down the loan amount to cover the costs of the court action as part of their service to those claimants. Many of the claims were abandoned, and the loans for which Barrington had liability were left unpaid. Barrington failed to perform its professional duties to its clients, which put Barrington in breach of its contract with Impact. Impact Funding sued Barrington for recovery of the loans and was successful. The result, however, was that Barrington went into liquidation. So in order to recover the loan amounts, Impact Funding had to bring a claim against Barrington's insurers, AIG. The insurance policy provided cover for losses arising from the performance or failure to perform legal services. It excluded liability for breach of contract for the supply of goods or services in the course of providing legal services. At first instance, the judge held that AIG was entitled to rely on a limitation of liability clause which excluded liability for debts arising from the services provided. The Court of Appeal then reversed this decision and decided that obtaining loans on behalf of clients was part of the professional service provided by lawyers and was not a standalone service. Thus, AIG was not entitled to rely on the limitation of liability. The question for the Supreme Court was whether or not the limitation clause should be interpreted narrowly and exclude the liability, as the Court of Appeal had found, or whether the High Court had been correct in disallowing the claim. So before we look at the Supreme Court's decision, we have our final poll of this webinar, so please use your voting buttons. The question is, should AIG be liable for the loans given to the claimants but secured by the lawyers? Click A if you think the Court of Appeal was correct. The obtaining of loans was part of the service offered by the law firm and was not a standalone service. And click on B if you think the High Court was right when it said that obtaining loans was outside the scope of the legal service provided by Barrington.
And most people have gone with A.
If you agreed that obtaining of loans was outside the scope of the professional service provided by the law firm, allowing the insurer to exclude liability for the loan amount, then you were correct. The Supreme Court concluded that limitation of liability clauses were, as a general rule, always subject to a restrictive interpretation. However, the law lords felt that this should not be the approach that is always taken. In the current case, it made more sense to read the limitation clause in the context of the entire contract of insurance. When the insurance contract was read as a whole, and against the policy background of insurance contracts for solicitors, it sought to cover breaches of solicitors' professional conduct in connection with legal services to their clients. This was not the same as breaches of obligations arising from contracts of supply of services used by them in the course of their provision of those legal services. That is to say, the contract between Impact Funding and Barrington was in addition to, not part of, the legal service offered by Barrington. It was clear that Impact Funding obtained a financial gain from the arrangement and that the contract was between themselves and Barrington, and not in the name of the claimant. Although this may seem a surprising result, and I know from the poll it surprised a number of you, the context of the insurance contract was clearly influential to this decision. The overall approach has generally been to narrowly construe the terms of the clause, rather than to look at the limitation clause against a wider background. So what practical advice can we take from this? When drafting a limitation clause, make sure the wording is accurate and reflects exactly what it is you want to exclude. In this case, the court took a wider view by considering business efficacy and public policy objectives. However, policy objectives may not always be in your favour, and as such, it's best practice to be as specific as possible in your contract so as to avoid too narrow or too wide an interpretation of your clause. That concludes today's webinar, and now there is some time for you to ask questions. As I mentioned at the beginning, questions can be submitted by typing in the chat box. While you're doing that, I would just like to take the opportunity to remind you that this is the third webinar in our series of 4, so please do log in to the final webinar, where we'll be exploring issues around the death of a contract and the necessary estate planning that follows. That final instalment in our life cycle of a contract series will take place on 25th April. If you'd like to find out more about our firm's webinar series or to catch up on previous webinars that you might have missed, the link to our webpage is on the screen now.
Well, there don't appear to be any questions at the moment, but as Claire said, if there are any further questions, please do feel free to contact myself or Claire. Our contact details are on the screen. And just remains to be said, thank you very much for joining us today.
Yes, thank you. Bye.